Welcome back, everybody. We're going to turn now to our second panel of the day up on diffusion models, international privacy updates. And I would like to introduce our panelists and also encourage them to say anything else they want about their practices. We have Ray Liu from our Beijing office. Ray is the office head of Beijing and also works with privacy and cybersecurity issues with many of his technology clients there. Ron Moscona is a partner in our London office and is very active with privacy in the EU and the UK and with artificial intelligence issues and the many new EU laws about online platforms and technology. We have Dave Townsend, who's in our government solutions and investigations practice group. And he's one of our international trade experts who's going to be talking about some of the international trade issues that have come up related to privacy, which will be key for companies, especially who have US-China business. And then Jeanette Wong is a partner in our Hong Kong office. And she practices in a number of different areas, including a bunch of different online issues, including payment scams, and she's going to be talking about that. So welcome, everybody. Thank you so much for participating. Here's all of our wonderful speakers, and we will turn it over to Dave to start.
Great, thanks, Jamie. I'm going to be covering the some recent developments related to data transfers from the United States internationally. And if you could go to the next slide, please. So I'm going to start out by covering a little bit on the legal architecture that gives rise to this development. Talk about the object and purpose and why these rules are being proposed, including why they're being proposed now. And then we'll just sort of walk through what the proposed rules are and how they may impact different companies. So I'm Dave Townsend. I'm an attorney here in Minneapolis, specializing in national security issues. From a national security perspective, the recent developments are following a trend of increasing attention to information communications technology as well as data. So there was an executive order issued at the end of February called Preventing Access to Americans' Bulk Sensitive Data and U.S. government-related data by countries of concern. And the rest of what I'm going to talk about today is basically outlining a proposed rule that the Department of Justice published on March 5th. That would implement that executive order, EO 14117. And so although from a national security perspective, this is a development that makes a certain amount of sense relative to the other communications and data priorities that have become a central focus of the US government from a data privacy perspective and a data transaction perspective. It's a pretty broad and sweeping proposal from the Department of Justice that I think a lot of companies and a lot of industries will want to keep an eye on. Next slide. So why are we looking at this issue and why are we looking at it now? There are a couple of case scenarios that I think policymakers all agree on need to be addressed. And I've briefly summarized these here. One was a case of a fitness training app revealing the locations of military personnel outside of the United States. You don't have to be imaginative to understand why that's problematic. There's also this article from the New York Times where the authors basically purchased data on the open market and then did a bunch of research and analysis of that data, which allowed them to track US military officials, law enforcement, and high-profile attorneys as they went about their day-to-day and private business. And so these all give rise to really central is US government data and potential issues that could come up for US national security related to transfer of that data outside the United States. Next slide. So the entirety of what this rule would address is data transfers about U.S. persons from the United States to a non-U.S. location. And the purpose and intent of the DOJ proposed rule would be to do something about the case scenarios that we looked at on the last slide, including tracking of individuals such as the military and federal law enforcement. But also in terms of the timing, I think the rapid increase of artificial intelligence and LLMs have really fueled a sense of urgency in the U.S. government that they need to do something on this front. And if you look at the DOJ proposed rule, which we provide a link to on that second slide, you'll see at the beginning of it, them talking about those use case scenarios that we mentioned, but also the fact that AI sort of enhances all of this risk, sort of exponentially, right? Because you have the ability now to train platforms to analyze data at speeds that were previously sort of unheard of. And that access to bulk data, both for training an AI platform, but also in terms of actually using the data itself, can compound the risk to U.S. national security. And national security, I think, defined not only as national security from the U.S. government perspective, but also in the corporate sector, allowing U.S. companies' data to be used in ways that are inimical to U.S. national security. Next slide. So getting into the architecture of the rule, a couple things about this rule. One is that the way DOJ has proposed the rule, it would require companies to look at the rule and determine for themselves whether a particular transaction is restricted or prohibited. And if they get it wrong, if they violate what would be the rule, then there would be penalties under U.S. law for a company or an individual that violated the rule. And so you really just have to work through the key definitions of the rule if you're a compliance specialist and or an individual, to figure out whether the kinds of transactions you're looking at undertaking would be subject to a prohibition or a restriction. And obviously, because it's only a proposed rule, it's important to remember all of these concepts are under further review and subject to change. And the Department of Justice is going to publish a proposed rule, which I think is due at the end of August, and then there'll be a final rule. And so the prohibitions and restrictions we're talking about here wouldn't go into effect until the effective date of that final rule. But you see here the different kinds of data that would be subject to restrictions. There's two broad categories. One is sensitive bulk data, which we outlined. There's 6 subtypes of that. And then another is U.S. government data. With respect to the sensitive bulk data, you can see there that there are particular types of industries that are sort of more targeted for restriction here. The personal identifiers is pretty broadly defined and would capture, I think, a lot of companies in the software or software app space. And then you see like the biometric identifiers, and the genomic data is more targeted to health data and companies in the biotech space, as well as the personal financial data, obviously, is more looking at the financial sector and banking sector. Next slide. So again, key definitions here. Countries of concern you see listed here. This is only the beginning, in the sense that I think as time goes on, DOJ and the enforcement agencies are likely to add to this. And then a covered person, that is a person to whom data transactions are restricted or prohibited, is defined here. And it's fairly common sense, although it does cover broadly entities that are 50% or more owned by a country of concern, or have their principal place business in a country of concern. And then US persons are defined there, again, sort of intuitively, but the broad structure here is that's regulating transactions relating and involving data from US persons to covered persons with a focus on the countries of concern. Next slide. Transaction is very broadly defined, but there is also this limitation in the proposed rule that it would target bulk data transactions. And what is bulk data? Well, it would capture data as low as 100 or as high as 1 million US persons, which if you're involved heavily in data, that's a pretty small number, even on the high side, again, subject to change. And then it would regulate or prohibit specific kinds of transactions involving bulk sensitive data or US government data. We'll look at more at that on the next slide. There are exempted transactions, which are really important for particular industries. Exempted are personal communications and informational materials. There's also a pretty broad carve out for financial services and payment processing if you're in the financial and banking sector. Next slide. So here are the 4 kinds of agreements that would be subject to prohibitions or restrictions under the rule. You have data brokerage agreements, which is like selling data that's collected to another person. You have vendor agreements, someone providing goods or services, employment agreements, again, sort of intuitively defined in investment agreements, where somebody takes an investment stake in a company. All 4 of these concepts are fairly broad in the sense that they would capture potentially all sorts of industries. And then if you're engaging in these kinds of transactions, what does that mean? Next slide. I've briefly outlined here how the rule is set up. You have prohibited transactions relating to bulk data brokerage transactions, as well as human genomic data. So there's prohibited transactions, and then there's presumably less sensitive restricted transactions, which are employment agreements, investment agreements, and vendor agreements. Those will all be permissible if subject to certain mitigation guidelines that are not yet set forth under the rule, but will be prior to implementation of the rule, which you can see the effective date. We don't know of this rule because this is just an advance notice of proposed rulemaking. But it would, at the very earliest, have to be at the end of this year or early 2025. And again, just a reminder that these transactions that would be restricted or prohibited only are restricted and prohibited to the extent they involve bulk transactions of those kinds of agreements. Next slide. So just to finish up here, if you are looking at this rule, if you're a company, you're not sure whether this rule might have any impact, this is just a brief outline. You would want to look at, do you have the kind of data that's proposed for regulation? Do you have the kinds of covered transactions? All businesses have the kinds of covered transactions that are implicated there, but whether they're bulk data transactions is perhaps a separate matter depending on the kind of business and industry you're in. And then do you have transactions that involve or have the potential to involve the countries of concern? Obviously, notably there was China, which a lot of companies that have business with China would want to look at this to see how it might impact their regulations. And then to conclude, just some really open-ended questions that I think will have a huge impact in how broadly this rule will ultimately affect companies. What are the security measures? What does it mean if a transaction involves sensitive bulk data or involves US government data? The ANPRM, DOJ doesn't really say at this point. There is a potential for licenses of transactions. I haven't talked about that, but it's sort of unclear under what circumstances such authorization would be given. And then another big one is just under what circumstances does a transaction take place? The proposed rule says that mere access is enough, which again could involve a lot of different business operations. So that concludes my section, and I'll turn it over to Ray.
All right. Thank you very much, Dave. Appreciate the insights. Ladies and gentlemen, so I'm ready to share some good news here about a data compliance practice, actually, related to China, especially from the international business perspective. So my name's Ray Liu. I'm the managing partner of Dorsey's Beijing office. I joined Dorsey in 2013 and actually opened the Beijing office for Dorsey in 2015. That's the year before the PRC cybersecurity law was enacted. So essentially, our Beijing office witnessed the entire process of China's data and privacy regime evolving from essentially nothing to a pretty much complex system right now. So I'm ready to walk you through the regime, sort of zooming out from the big picture perspective, and then focusing on the cross-border data transfer issue, especially the latest developments. So next slide, please. So here's the agenda. So we're here to, first of all, provide you guys with a high-level overview of the PRC data security and privacy protection law regime. And secondly, so we'll explain what the requirements are in terms of transferring data, particularly the personal information cross-border to overseas data recipients under the current rules and the prior rules. And thirdly, which is actually the focus of my presentation today, so we're going to talk in length about the regulations or provisions. So these are the translations that we use interchangeably on promoting and regulating cross-border data flow issued by Cybersecurity Administration of China, also known as CAC. And that new rule became effective on March 22nd, 2024, which is essentially less than a month ago. And essentially, what this new rules means has pretty profound and I would say encouraging impact on multinational companies, either doing business in China or doing business with Chinese parties. So it's a very relaxing set of rules, which is sort of unprecedented, especially compared with some of the pretty stringent laws and requirements that we have seen. So today we'll be focusing on the new rules. Next slide, please. All right, let's have an overview of the Chinese data protection law regime. So let's start with the big code, what we call PRC Civil Code. Well, bear in mind that China is a civil law country versus a common law jurisdiction. So the Civil Code is a very comprehensive legislation that codifies all the private laws of China. It has like 1,260 articles. It's very extensive legislation in the entire history of PRC, the most extensive one, actually. For the first time ever in PRC civil law, it introduces the provisions on the right of privacy and protection of personal information. So you can see that the privacy law has sort of already intertwined with the existing civil law system. And talking about the cybersecurity law or the personal information protection law, which are pretty well known to the audience here, I think China has a really right now robust system consisting of 3 pillars of the PRC data law, namely PRC cybersecurity law that became effective in 2017, in a data security law effective from 2021, personal information protection law effective from 2021, and PIPL, also known as PIPL, that law governs personal information processing activities carried out by entities or individuals within China. That law has also some extraterritorial reach. So together, these laws aim to protect both the security of the data infrastructure, public interest, as well as the privacy rights of individuals, placing various compliance requirements on companies operating in or dealing with data from China. Some of the requirements, as I mentioned, are pretty stringent. They're also supporting rules, implementation rules, guidelines issued by CAC or other regulatory bodies on cross-border transfer, data security, CIIO, critical information infrastructure operator. There are also rules on industry and local rules as well in provinces and cities. So right now we have a very robust and comprehensive system that we're dealing with. And CAC, Cyberspace Administration of China, is the main regulatory body at the central level and local level. Next slide, please. Talking about cross-border data transfer, so you have to look into Article 38 of PIPL. That essentially set forth 3 data transferring mechanism, which means if you need to transfer personal information outside of territory of China due to business or other needs, you have to meet one of the conditions, right? You either have you have to pass a security assessment conducted by CAC, that's the most stringent one, or you have to get certified by a specialized agency for protection of personal information in accordance with the provisions of the CAC, or you enter into a contract with the overseas recipient, and that contract was formulated by CAC, and of course, some of the clauses are now allowed to change. And actually, there's a 4th catch-all version which says if you can meet other requirements or conditions prescribed by laws and administrative regulations of the CAC. Actually, this new rule that I'm going to talk about fall into the catch-all categories, meaning you don't need to go through one of the 3 transferring mechanism. It is prescribed by law. These are allowed as exemptions. Next slide. So the regulations or provisions on promoting or regulating the cross-border data flow is actually, I would say, a very anticipated new rules, widely welcomed and even celebrated by market players. Because as you can imagine, when you have a very low threshold for sorting out and complying with one of the 3 pretty harsh or sometimes difficult transferring mechanism, so it's pretty burdensome for companies to comply with. And actually, CAC recently, prior to the announcement of new rule, got swamped by various filings and assessments requests. So this rule is absolutely a game changer. So it introduces substantial changes to the current rules over cross-border data transfer, including exemptions from filing the standard contract, applying for certifications, or conducting a security assessment, or it actually introduced higher thresholds for these 3 transferring mechanisms, make things easier for the market players or the data processor. Next slide, please. So let's look at the eased requirements here. First of all, the heightened thresholds. We don't have time to go through each one of the changes, but you can see the previous thresholds, some would argue, are very stringent, even draconian. The new thresholds under the regulations or provisions are more manageable or feasible. Just give you one example, right? Suppose you are an internet company, right? You process personal information of 1 million people, right? Even if you only transfer personal information of one individual cross-border, outbound, you have to go through the security assessment, which takes weeks or even months, right? But look at the new threshold accordingly. So the rule has significantly changed to that when you actually transfer personal information of more than 1 million individuals cross-border within the same year, not the previous year, within the same year, and then you will have to go through the security assessment and get it done. So that's much easier compliance requirements and much heightened thresholds. So that will save a lot of companies, including even some tech companies, from the hassle of going through the security assessment. And of course, there are also exemptions, and there are also heightened thresholds for filing the standard contract and obtaining a certification as well. Next slide, please. So the next 2 slides, I will talk about in total 6 exemptions as prescribed by the new regulation and rules. remember, as I mentioned, so all of these 6 rules will be essentially put in the basket of the category 4 of the Article 38 of PIPL, which means they are conditions prescribed by laws or rules by CAC. So which means you don't need to go through one of the 3 transferring mechanism. You're just fine, right? The first one is what we call small scale transfer. So if you're transferring personal information of less than 100,000 individuals to overseas recipients within the current year, you don't need to do one of the 3 mandated requirements. But so long as there's no important data, no sensitive information, if you're not a CIO, that is fine. The second category is necessary for contracts, right? For the outbound transfer of personal information of individuals necessary for performing contracts to which such individuals are parties, right? So what are these contracts? Pretty basic and daily, right? Including cross-border shopping, online shopping, mailing, delivery, courier, remittance, payment, account opening, flight and hotel reservation, visa processing, examination services. So these will make a lot of business life easier for sure. And thirdly, necessary for HR management as the third exemption here. This is huge because, as you can imagine, a lot of companies, they're sort of stuck. They were stuck between a hard and rock place previously because they had to choose, do we need to do some fundamental changes to our global HR practices, or do we need to stick to it, risking violating PRC law? If the outbound transfer of the employee's personal information necessary for implementation of cross-border human resource management in accordance with the labor rules and regulation developed or collective contracts executed in accordance with the rule, that is exempted, which means you could possibly safely transfer personal information of the employees cross-border, outbound from China, which is exempted. But of course, you still have to comply with the other requirements under PIPL, especially the principle of minimum and necessary, which is mandated by PIPL. And next slide, please. Emergency situation, which is pretty self-explanatory. I will not further elaborate. And the next one is very interesting. No personal information or no important data. Because if you're doing international trade or cross-border transportation or academic issue or transnational manufacturing process or marketing activities, if the data do not fall within the scope of personal information, are they allowed to freely transfer? The answer is yes. Now, the rule makes it crystal clear. So long as these are not important data, but important data is well-defined definition. It has to have some implications with national security or public interest, and the rules make it clear that the government has to name it, right? The government CAC has to announce it that it is important data. Otherwise, you don't need to worry about your data if it's not defined by the government or announced by the government. So the last category is PI, personal information collected and generated outside of China. If the information were collected outside of China, they were sent to China for processing and then sent it outbound again. So long as it does not involve personal information of PRC individuals or important data, you're fine. These can freely transfer. Next slide. Probably we don't have time to go through the new procedures, but you can see the valid period got prolonged. It's relatively easier and more feasible to apply for extension. We have a simplified procedure for security assessment and standard contract. Next slide, please. Free trade zone. China has 21 free trade zones, Beijing, Shanghai, Guangdong, you name it. So all the free trade zones have the authority to create their own list of data to require security assessment, standard contract, etc. So this is so-called negative list. So long as it's not on the list, it is exempted in this particular free trade zone. So free trade zone actually encourage more business being set up in those zones. Next slide, please. So What remains unchanged, we'll probably do not have time to go through each one of them, but we'll have to say we'll have to comply with PIPL regardless of the new rules taking effective. You still have to send out the informed consent, obtain the separate consent from the data subject, have to do the PIPIA report, etc. And you still have to make sure that there's no sensitive personal information because there's no significant relaxation for cross-border transfer of such. And we don't have time to explain what the sensitive personal information, but you guessed it, the concept similar: biometrics, religious beliefs, specific identities, information of minors under age 14, for example. Next slide, please. So what's next? Just to wrap up, the regulations are intended to ease the burden of compliance requirements for cross-border transfer and to stimulate economic growth and attract foreign investments, to make life easier for both international companies as well as domestic companies going abroad. In light of these new changes and the ever evolving and ever complexing legal regime in China, we recommend that the companies in the market conduct data mapping, implement data tracking mechanism to effectively monitor and assess the volume of personal information and important data, if any, transfer out of China. So we have to keep track of the changes and promptly update our policies and adjust data management to ensure compliance and mitigate risks. So with that, I will turn it over to my partner, Ron Moscona, in London to talk about the exciting Artificial Intelligence Act in Europe. Thank you.
Thank you very much, Ray. So we're going to jump into something completely different now. As many of you might have heard, the EU introduced a fairly comprehensive regulatory legislation in relation to artificial intelligence, and I will talk about that. My name is Ron Moscona. I'm a partner at the London office of Dorsey and Whitney, specializing in all aspects of technology, intellectual property, data privacy, and regulatory issues. So we heard two, in our international panel, which is where we're at the moment, we had two presentations that focus very much on data transfers, and this has a lot to do not just with privacy, but also with geopolitical relationships and trade. So it's a combination of both privacy concerns and real trade issues and competition in the international market between two major players, mainly the US and China, but also across other countries. And of course, the EU had its own fair amount of restrictions on international transfer of data that tends to focus quite a lot on privacy concerns. What we're talking about now is something completely different. And it's important to mention that because in the context of AI, there's also a lot of export control type trade war issues. And of course, there are a lot of restrictions being imposed today by countries in Europe and the US on the exports of high-end semiconductor devices that are necessary to process AI and all of that. And this is an important issue, but this is not what we're talking about today, because what we're talking about today is the European Union AI Act, which is an attempt to introduce a fairly comprehensive regulatory framework to deal with the risks that the artificial intelligence technology poses to consumers, to people, to society. So this is very much along the line of regulatory framework for pharmaceuticals, for electric devices, for automotives, and things like that. This is the context in which we're dealing with here. Having said that, as you will see when we go a little bit into the details, a lot of it is actually focused on privacy issues. So a lot of the concerns that the EU seems to be alerted to in the context of AI are to do with privacy concerns. So let's jump onto the next slide, please. So this will try to give an impression about what this AI legislation is all about. And I think the first thing anyone want to know is, why is that important? Why is that important to me? And the answer is fairly simple. This is a regulatory framework that, if you find yourself within it, there's a fairly involved compliance requirement, and it depends on what you do and what the product is. But if you are regulated, this is being this is a regulatory framework for introducing a product onto the market, and that applies to anyone who introduces a regulated product, if you like, or a product that comes within the scope of the legislation into the market in the EU. So it doesn't matter if you're a Chinese company or a Russian company. Well, we don't deal much with Russian companies these days. A Canadian company or an American company or a Brazilian one. It's the question whether you are placing a product on the market in the EU, and that's when a product or a service, and that's when you might come into the within this regulation. And so the main question is really, what is covered by this regulation? Am I within it, or am I not within it? And this slide perhaps will give will help me to give you an idea about the scope of this regulation. So there are, if you like, 4 elements, as you can see, in this regulation. There's the element about prohibited AI systems. Even though it takes half of this slide, it's actually a tiny part of the legislation. And the only really important thing here is the first indent that you see here. AI systems that are designed for fraud are prohibited. That doesn't really add a lot to the law, because fraud is covered by other laws, and it's so the law says that AI systems, essentially AI systems designed for fraud, are unlawful. Other things to do with privacy issues. I'm not going to go into details, but some of these issues are already also covered by existing data protection laws, GDPR. So, for example, biometric systems designed to deduce sensitive categories of categorization of individuals are banned. But that is not really surprising, because GDPR already says that any processing of these sensitive or special categories of the same ones that Ray mentioned, like religious beliefs, political alignment, and all these kind of sensitive issues, that you can only process them usually only with the consent of the data subject. So, of course, if you have an AI system that is designed to deduce these things without your consent, then it's already prohibited under GDPR. So the prohibited list is short, it's narrow, it's not that interesting, and there's nothing particularly surprising about anything there. Then there's the category of rules that apply to all AI systems. And these rules are actually very limited. They're transparency. It's very important, and it's a useful thing that the EU introduced. These are the transparency obligations for all AI systems. Really, I mean, and putting things in context, this regulation is not necessarily about generative AI. It's not necessarily about ChatGPT. This is about every AI. So it's the AI that operates the self-driving cars. That is the AI that operates your legal research database kind of system. It's the AI that operates a medical device. So it deals with a lot of AI which is used in industry, in practical things like flying planes or driving cars or things like that. So the transparency obligation, although it applies to all AI systems, I think that is very important, because this is the one bit of this regulation that deals with the use of AI in social media, in general media, in communications, because that's where it really is relevant. There are two requirements that apply to all AI systems that are put on the market in the EU. One is that when an AI system interacts with a human, that needs to be disclosed. So the human needs to know that. So if you're ringing up your service organization and you get a reply, and that reply is AI, so they have to I guess, introduce themselves. I'm your AI help desk, and that will be the reality of our lives, if not next year, then in 3 years' time, right? So when you interact with AI, you have to know about it. And the second thing, content which is AI generate needs to be labeled as such. So this is the rule. I think, like all rules, if you start digging under the headline, you can scratch your head and wonder how it's going to be implemented in practice, but that is the nature of the law. But so the principle is that labeling AI content and disclosing when you are dealing with AI, which is nice, and that applies to everyone, and that's useful to know if you are introducing a interactive AI system into the market. And then you have the heart of the law. The heart of this legislation is about a regulatory framework, as I say, a full-blown regulatory compliance framework for high-risk AI models. And I will talk a little bit about high-risk AI models, not in great detail, but a little bit. There are two types of them. One, AI models that form part of regulated products like aircraft and cars and things like that, and other AI models which come under specific sectors that the EU legislation has identified as high risk. If you are within those, then you have a significant compliance burden going forward. And lastly, the legislation deals with general purpose AI model. General purpose, there are lots of course, this is a new technology and it's moving a lot. And the idea of general purpose AI models, I don't think it's identical to saying that it's the same as generative AI. There is obviously a certain overlap. General purpose is basically defined in this legislation as AI models that are not specific to any particular user case. They're not designed for any particular implementation. They can be used by other companies or by other providers for all sorts of purposes. So the generative AI models, the large language models, at least, they're an example perhaps of a general purpose AI model. They're not necessarily the only ones. There could be other fundamental AI models that can still come under this category without being necessarily generative. So the general purpose AI models, they have certain requirements applying to them, even though it's not a full-blown regulatory burden. So very quickly, we'll jump to the next slide, please. You can see the types of regulated products where the AI would also be regulated within those products. There's nothing special about it because these are regulated products anyway. So if you are making a medical device which includes or is an AI model, then it would be regulated as a medical device in the EU. And this legislation adds a little bit more detail about how the AI elements within it should be regulated. But it does, I mean, you were regulated before this legislation, and you continue to be regulated after this legislation. So it's not adding a huge amount of information. Next slide, please. Here we can see the perhaps the most significant addition that this legislation introduces, which is defining. These are 5 of 8. The next slide lists another 3 sectors within which certain user cases are defined by the legislation as high risk. Now, this is important because if you are within the particular user cases that are listed within those 8 sectors, then your product or your model is deemed to be high risk, and then it's subject to full-blown regulation, just like manufacture of pharmaceuticals or medical devices or cars or aircraft. So you can see the type of things, and I emphasize, it's not everything to do with education or everything to do with employment. It's certain user cases within those situations. So in relation to education, admission, assessments, things like that. Employment is about recruitment, promotion, things like that. AI systems that are within those user cases are treated as AI and subject to serious regulation. Next slide, please. Here you have a few others. These include the law enforcement, administration of justice. So these kind of things, if you are within those user cases, you become regulated. Next slide, please. The emphasis here is that there's a lot of things that fall outside the scope of this regulation. And you can have a look at this slide later, and it's quite interesting. One example I would give, you could be using AI in healthcare. If it's not a medical device, it's not considered high risk. So there's huge elements of use of AI in really important areas that could be actually quite sensitive that fall outside of this regulation. So other than the general transparency requirements, for example, if it's not a regulated device, you could use AI in connection with pharmaceuticals, in connection with clinical trials, in connection with development of pharmaceuticals. This is not considered high risk. It's not regulated under this legislation. There's tons of other things like banking. If it's not access to banking, it's not regulated. Next slide, please. These are the kind of compliance issues that you'd have to deal with. They're full-blown compliance requirements, including engagement with regulators, transparency, a lot of good, important stuff. It is significant if you're within it. And then next slide, please. Lastly, we have the regulation of general purpose AI models. The legislation says very little about it. It's not insignificant because you have very significant requirements for maintaining technical documentation, which must be available to regulators if they want it. You have to provide disclosure to the people who license the general purpose AI model from you so they can comply with their requirements. You have to comply with copyright policy. You have to publish information as to how you trained your data and where you got and that reflects some of the issues that are now in litigation, as Jamie mentioned earlier. So there are significant issues here, but all of these issues are captured in 2 pages of legislation. There's not a lot of detail there. And like everything in this legislation, but particularly in connection with the general purpose AI models, it all depends on how regulators would actually develop this and what they will make of this, because there will have to be a database of general purpose AI models with systemic risk, and regulators will then need to decide what they do with that database and what they do with the technical documentation that is presented to them, and what they do with the requirements to evaluate, assess, and mitigate risks. These are very, very general requirements, and you can make whatever you want from them. So if the EU is going to put a lot of professional regulators into implementing this, then this is going to be a serious regulatory compliance program. At the moment, it's just very, very general language in a piece of legislation. So that is where we are. I came to the end of this. It's very bold on the one hand, but it's quite premature on the other hand, because it's a bit of a patchwork. It kind of like says a few obvious things like regulated products will be regulated, and it identifies very specific sectors in which it says products will be treated high risk, but then there's vast areas of trade where the legislation doesn't go into, and it would require new legislation to cover them. So there's a lot of new stuff there, but it leaves a lot of issues uncovered as well. So with this, I will wrap up and allow Jeanette to come and talk about wire fraud and how Hong Kong practitioners can help with that.
Thank you so much, Ron. Hello, everyone. Welcome and thank you for joining today's session. I'm Janet Wong, a partner and head of Hong Kong office, specializing in intellectual property, cross-border financial disputes, and asset discovery. Just now, our fellow speakers, Dave, Ray, and Ron, have shared their expert insights on the latest legal development of data transfer of an AI in the United States, mainland China, and Europe. Next, I will be switching to an equally important topic, cybersecurity, with an emphasis on the AI elements. I'll be discussing the critical issues surrounding the international wire fraud. Next slide, please. So I will provide a brief overview of wire fraud. providing some statistics from the United States and Hong Kong, and then talk about why Hong Kong is an attractive destination for wire fraud, the current wire fraud trends, including the one relating to AI, and the current legal development in Hong Kong, as well as some practical tips to prevent wire fraud. Next slide, please. So what is wire fraud? It is a type of fraud that involves the use of electronic communications to execute certain fraudulent schemes that deceive individuals or entities into sending money electronically. So according to the FBI's latest Internet Crime Report, in 2023 alone, the United States witnessed over 880,000 complaints with potential losses exceeding $12.5 billion. Similarly, in 2023, Hong Kong reported more than 39,000 deception cases, resulting in losses surpassing 9 billion Hong Kong dollar, which is approximately $1.15 billion. And among them, 70% of these cases are internet related scams, such as online shopping, investment scam, employment scam, social media scam, and telephone deception cases. So these staggering figures not only reveal the extensive reach of wire fraud, but also highlight the urgent need for robust and proactive strategy to effectively combat this criminal activity. Next slide, please. So why Hong Kong is an attractive destination for wire fraud? Hong Kong, as a global financial center, possesses several attributes that unfortunately make it a prime target for wire fraud. So first of all, it is a sophisticated yet open banking system that facilitates swift international transaction that provides a perfect setting for quick fund movements. Also, secondly, Hong Kong is strategically located close to the major Asian economies, serving as a primary gateway to mainland China, making it uniquely positioned in global finance. Also, while Hong Kong has advanced digital infrastructure that promotes efficiency and connectivity, it also introduces significant vulnerability to cyber attacks. Next slide, please. So in the next two slides, I have set out the different key types of cyber fraud and emerging trends for your reference. As technology evolves, cyber attacks have becoming more sophisticated and new types of wire fraud have emerged. I'm not going to explain these types of fraud in detail at the moment. Instead, I would like to focus on one of the emerging trends associated with the rise of AI. The use of AI to create deepfakes present new challenges, as this technology can be employed to facilitate more complex scams. Next slide, please. So this three table shows the type of wire fraud throughout the years. From 10 years ago about very popular CEO scams, business compromise scams, and now during the COVID time, we have a COVID-related scam, and during the past few years, the rise of cryptocurrency and NFT scam. So nowadays, with the rise of AI, it also create a new type of scam, the deepfake scam. Next slide, please. So in this slide, I would like to talk about a very recent, significant, and sophisticated wire fraud case in Hong Kong. Just 2 months ago, in February, a finance worker at the Hong Kong office of a multinational corporation was deceived into transferring 200 million Hong Kong dollar, which is approximately 25.6 million US dollar, through 15 transactions to multiple bank accounts. The worker believed that he was actually following the instructions from the company's CFO, but in fact, it was not the case. There was actually a bunch of fraudsters employed deepfake technology to mimic the appearance and voices of the CEO and also other staff member of the company during a fabricated video conference call. So although initially the finance worker was suspicious because of a questionable email, but after attending this fabricated conference call, seeing the faces and voice of the CEO and other staff member of the company, the worker was eventually convinced by these realistic deepfakes and proceeded with all these 15 transactions. So this incident marks the first known case in Hong Kong where victims were deceived in a multi-person video conference setting. These cases also highlight the increasing use of advanced technology in financial crimes. Next slide, please. So I now turn our focus to various legal mechanisms available in Hong Kong for freezing and tracing assets. Currently, Hong Kong Police and the Court of Hong Kong have the power to freeze bank accounts within the territories. The Hong Kong Police can issue the letter of no consent, or what we call LNC, which serve as an informal mechanism to freeze bank account suspected of containing proceeds from fraud. However, this mechanism is temporary. Typically, an LNC is valid for up to 6 months and is subject to regular review. So in 2021, the Hong Kong Court of First Instance declared the LNC the letters of no consent issued by the Hong Kong Police ultra vires, which is not legal, not constitutional. 2 years later, in 2023, the Court of Appeal reinstated the constitutionality of the LNC. And just last week, the Court of Final Appeal handed down a decision in this case, affirming the legality of the police operation involving the letter of no consent to prevent the dissipations of funds in criminal investigation. So this finally marks the end of the challenge to the legality of the LNC, which is now still constitutional. Next slide, please. As mentioned, the LNC issued by the Hong Kong Police is a temporary one. And oftentimes it is very uncertain as to whether and how quick the Hong Kong Police is going to issue the LNC. Therefore, it is always advisable, especially if substantial amount of funds is involved, to obtain a formal court injunction from the Hong Kong court to freeze the bank account. The two main types of injunction that we usually sought on behalf of the plaintiff are the Moravian injunction and the proprietary injunction. In the interest of time, I'm not going to discuss these two types of injunction in detail, which you can refer to the slides for more information. So in brief, each type of injunction has their specific threshold and requirement. Depending on the circumstances, we may apply for both injunctions to maximize the likelihood of recovery of the assets. Next slide, please. So to trace and recover assets, plaintiff can also apply to the court for a banker's discovery order under Section 21 of the Evidence Ordinance in Hong Kong. So this order permits the plaintiff to inspect and take copies of any entries in a banker's record, which can help identifying the defendant, their identity, and also can help identify and recover the assets involved in the fraud. Next, please. So dealing with wire fraud presents various challenges. One of the challenges that we often encounter is the service of court documents outside of jurisdiction. Traditionally, scammers would use Hong Kong companies to receive funds. More recently, there has been a shift towards using individuals from mainland China or other foreign locations to set up these accounts. and these accounts often lack genuine addresses. Having said that, the Hong Kong judiciary is increasingly opened to grant order of substituted service and to allow using modern communication methods to effect service of court document, such as in a case that involve allowing the plaintiff to serve the defendants using email or text messages, or even sending to their Facebook account or by WeChat. So in a case that I handled very recently, the court recognized the difficulties in reaching elusive defendants across border. And also we've got an order allowing service via email and SMS based on the contact information provided from the provided on the bank documents. So this flexibility is very important for effective and swift asset recovery in the face of international challenges. Next slide, please. So this is my last slide of my presentation, where I have outlined some practical tips to help prevent wire fraud. So basically, stay informed. Keep up with the latest wire fraud trends, such as the wire fraud tactics like deepfakes the fraudster are using, as we discussed earlier, and implement robust security measure, such as the very popular two-factor authentication, and also regularly train employees to recognize the sign of fraud. As technology advances, so also consider using advanced technology or some AI tools to enhance fraud detection. Also, we need to verify the sources meticulously, very cautious with unexpected requests for sensitive information or financial transactions. Always confirm the authenticity of such requests by contacting the sender through verified means. As I said, with the increasing use of deepfakes, try to verify with the person in person whenever possible. Maybe we can use some prearranged secret codes among the team members to confirm the identities, ensuring secure and reliable verification. So lastly, if fraud is suspected, act very quickly, because oftentimes time is of the essence in this situation. Immediately contact your bank to stop the transaction and recall the funds as soon as possible. Also, report the incidents to your local enforcement authorities. In the case of the US, contact FBI's Internet Crime Complaint Center, the IC3. And if the funds have been transferred to Hong Kong, report the case online through the Hong Kong Police online portal, the e-report center. Extra tips, make sure you save copies of all these police reports, obtain the contact details of all your police officers that have been handling the case, and get the case file number in all these jurisdictions. Getting all these details are very important and can assist in following up with these enforcement authorities. And of course, engage a trusted lawyer with the expertise who can help you navigate the legal systems and help with liaising with the banks and authorities, enforcement authorities in a timely manner, which is very important as time is of the essence. So in conclusion, awareness, preparedness, and swift actions are your best defense against wire fraud. So always stay informed, stay secure, and act fast when you suspect fraud. So thank you all for your attention and engagement during the sessions. And I hope this insight empower you to better protect yourself and your organization against wire fraud. And if you have any questions, please feel free to ask. So this is the end of my presentation. Thank you.
Thank you so much to our international panels. Very helpful and interesting, and so many things you covered. So I've put a slide here that talks about returning your completed sign-in. We will also have that at the end. Feel free to contact any of these speakers if you have questions about their materials. And we have some information here about how you can get the materials.